This is section 1.10, which you'll find in your book, which starts around page 150 and goes through to about 154, 155, and it's all about protecting designs and intellectual property rights. Okay, the idea behind this section is that as a designer or as a company that employs designers, when a designer comes up with an idea, what stops people from stealing or copying that idea? We'll go on to all those kind of cases. You'll know a lot of stuff about this already, just from the news over the years and products that you're into. But basically, the idea is if you do you own the right to your idea? How much of that idea is borrowed from something else? Is it a unique idea? And if so, if you're going to make money on it, then it's going to be a really successful idea. You kind of need to stop people from copying it, otherwise, you can't own that idea, and so on and so forth. So it's all about protecting your designs, that's stopping people from copying it, and do you own the right to ideas, and so on and so forth. And some of these things we're talking about are things you can use the law to help you with, which is usually quite expensive way, and some things in this country you have the rights to already given to you just by the way the law is set out. So we'll have a look at those as well. So the first thing to do is to understand what we mean by IP. Okay, so IP is intellectual property. That's something that has been physically created and did not exist before. It has to have a sense of uniqueness, and this uniqueness is essential when you're looking to get your intellectual property rights, your IPR, and that is something where you therefore go about protecting this original idea. But in order for you to protect it, you have to prove that it's a unique and original idea. Ideas are very complicated, aren't they, in a way, because some ideas are borrowed from something else. Some ideas, if you come up with a brilliant idea that's brand new, how do you therefore prove that it's unique, that it hasn't been copied from something else? That's all about intellectual property. So in your exam, if they talk about IP, they mean intellectual property. IPR, intellectual property rights, the rights given to you because of your original idea. Okay, now just have a look at this, for example. Many of us will know about knockoff goods and so on and so forth. So um, we've all seen that little symbol down there, that registered trademark. Um, and the idea around that, you'll know, is about protecting the rights of that company. We've all got used to logos and stuff like that, and we call these things trademarks. And these can be protected as well. These are really important to companies because when you when you buy into a brand, you connect it with their logo and with their tech. So sometimes, for example, Nike has built up such a strong brand image that they can just rely on that logo on its own, although they do have text as well, such as Adidas is the same. They have those three stripes. Now, three stripes, how do you therefore prove that that's original? If you think about the thing that three stripes, they didn't invent the stripe. They didn't invent the number three, so putting three stripes together. But they have got quite a good handle on how to make sure that people don't copy their stuff. So, for example, one way of copying Adidas stuff is put two stripes on instead of three, and so on and so forth. And yeah, so that's basically it. We know those as trademarks. So that's something you have to be familiar with, is the term trademarks. Okay, that's usually logos and text, and every major brand has clear logos and text that signify their brand and stop other people copying or buying into their market share. Okay, so take for example this company here. It's a company called Supermax. They were sued by McDonald's, or asked to close by McDonald's, because they sell burgers and they're called Supermax. But what they did, you can see inside the shop, they really have copied the brand in a lot of ways. It looks a lot like a McDonald's when you go inside, same sort of thing, pictures of the food above it, fast food restaurant. McDonald's actually sued them but lost. It was decided that they hadn't it infringed enough upon the trademark of McDonald's. They weren't using the same color scheme, they weren't using the golden arches, the M. So then you have to come down to whether McDonald's owns the word Mac, which it doesn't. It's a name. They always have the Big Mac and so on. So I think McDonald's felt they had a good case, and often these things that end up going to the courts to decide, and the courts felt that it wasn't an infringement. So Supermax is able to carry on being Supermax, much to McDonald's disappointment. And often you'll find that case. You'll find it in the music industry, where over the years, loads of people have said that other songs, Ed Sheeran, for example, was accused of copying someone else's song because it sounds like theirs, and then you're like, well, when you put a set of notes together, when does it become a copy of that song? And that's often what the courts have to decide on the intellectual property of that particular. Okay, so this is a good example of a company that did actually successfully keep hold of intellectual property rights. This is Flyknit technology from Nike. They invented a new way of basically creating a trainer shoe that involves a sort of weaving or knitting together of materials, so hence fly knit. So it's got all these properties that were really exciting for Nike. It was lightweight, it had this breathability and stretchy comfortableness because of its knitted nature, and they called it fly knit technology. And they patented it and they put it in particularly running shoes. It was very successful. Then Adidas bring out something called Prime Knit, okay, also a knitted trainer. And Nike actually sued Adidas on the grounds that they were copying their knitted technology. And because they patented it, it went to a court of law and it was found to be successful. That Adidas had basically just gone, yeah, that's a really good idea, let's copy it. And Adidas were forced to pay Nike and also to actually um, then they had to take that shoe off the market, I believe. And I don't know if they've since come up with their own version that doesn't infringe on the patent of Nike. But it was a really successful new trainer design. Something you haven't a lot of new trainer design in a while, but Nike had it there, um, and that was the example of them actually holding on to their intellectual. Um, in this country, we have a number of things which are given for free that you own from the beginning. So, for example, this is the copyright. You'll see this symbol around. People put this symbol on their work. Basically, it's a legal right automatically given to literary, dramatic, musical, or artistic work for 70 years after the death of the creator. Okay, so basically, if you create something, you have the right to that work for up to 70 years. That's why often you'll get the rights to a book. Well, a person died a long time ago, and the rights to that book will suddenly become available because it's been 70 years since that person died. Before that, a film company that wanted to make a film out of that book would have to pay the estate, the family of that person who wrote the book. But after 70 years, it may become available if it's just got a copyright next to it. And this was created in Britain in 1988 by the Copyright Designs and Patent Act. The creator has the right to give permission for their work to be used, often for a fee. This is therefore common with film, music, TV shows, software, artwork, theatre, musicals, books, etc. Okay, this is why when you create something in YouTube and you put some music over it, you're not allowed to because the music is copyrighted. You have to ask for permission. Now, often people will give permission for their work, but they'll do it for a fee. On top of that, you've got something called unregistered design rights, which is basically the idea that you can provide protection for designs so they cannot be copied. This applies for 10 years. So, say you did a sketch of something, you drew something, for 10 years, that is covered by the unregistered design rights, but it's only the appearance of the product and not the way it works. For that, you need a patent we'll come on to. Now, obviously, both these things are free to you. They're available to anyone who's being creative and creating something. But the problem is, you'll read this in page 151. The problem is how you actually go about enforcing that, proving that your work is original, proving that someone has copied your work. Those are the things that can be really difficult. Okay, so that's where often companies will then go on further to actually pay for their rights to be protected. Okay, where we come on to things like patents. Okay, so a patent is granted by the government. It's really important that the patent is given by the government of that country to the inventor of the idea for 20 years of protection from the idea being stolen or copied. They're only applicable to the working parts of a new invention, okay, or something that has been significantly improved. Okay, so very important. It's about the working parts, not the look of the thing, the working parts. Or if you've really improved something. So, for example, like Dyson, they improve their vacuum cleaners all the time, and then they apply for patents so people can't copy the way that vacuum cleaner actually works. Okay, often involves a patent attorney. Here's the problem: you have to pay a lawyer, usually a lawyer specializing in patent law. They'll go and check all the other patents to check that it's not already out there, that no one's copied it, that you can actually patent the thing because you can't patent anything. You can't paint patent things that already exist, like a wheel. Okay, so it has to be a unique piece of functional thing that hasn't been done before. They'll check all that, and then they apply to the Intellectual Property Office. Okay, and that process is quite complicated and expensive. And usually you will apply to different countries because each of them has their own patent offices. This is where it gets very expensive. If you're international, you have to make sure you apply to the Eurozone, to USA. And this is the problem when you come to a place like China, which maybe don't have the same patenting copyright laws. Maybe those countries, it's easier to copy those things, and you can't stop them from copying them. So this is why it becomes really difficult. But anyway, this is what companies do to protect their products, and usually those applications are accompanied by drawings. For example, this is something that was done. I think this is an Apple patent from last year. Foldable phones. A lot of people think foldable phones are the next big thing. This is a patent for their foldable phone, and you can see that the drawings include all the details about the mechanisms. Because remember, patents is about the working parts, the functional parts, not what it looks like. So often the thing doesn't look particularly interesting. It's not the aesthetics that they're looking at; it's the functional aspects of it, and then that thing will be patented if it's accepted to be unique, and no one else can copy that mechanism for a foldable phone. Okay, and that's how patents. Now, the other option you have is something called registered designs. You can apply for a registered design with the IPO, that's the Intellectual Property Office, which covers the appearance and decoration of a product. So now we're talking about the way things look, and this can last for 25 years. Take, for example, Apple. Okay, we've talked about functional things that might be patented, software, chips, any buttons like a fingerprint sensor when they had one. But then you've got the look of it, and then that can also be done through registered designs, the way the phone looks and is designed aesthetically. And then you've got to, this is where it gets difficult. How do you prove that that is unique design in terms of its aesthetic quality? Take, for example, the Google Pixel 3 also had a notch. Even the notch has the same way the curves around the notch go, but isn't exactly the same because it's quite more ugly and deep, and whereas the Apple one is wider but shallower. So there's things like that which come into play in terms of your IP, in terms of your registered designs. Fashion companies use these all the time because they're less concerned with function often and much more about the way something looks. Take, for example, a designer bag. How do you stop people from copying that look? Well, it comes down to things like trademarks and registered designs, where you register the design of that bag so that no one can just make a bag that looks the same as that. Okay, so registered designs go alongside patents to try and protect intellectual property rights. Last thing to talk about is this idea of open design. There are cases where designers or companies might choose to not protect their intellectual property rights and give them away. Here's one example here. This is the Thingiverse. This is a free online platform where people, when they create a 3D model for 3D printing or laser cutting, it then is they can upload it to this, and it's free for anyone to download and therefore use that model for free. So when you create something on a 3D package software, you own that rights through the Copyright Act, but you're basically, by putting it on Thingiverse, giving up your rights so that anyone can use it for free. So it's a great example of open sourcing. People aren't looking to make money, they're just looking to share their ideas